Good evening, friends. I am Muralidharan. I am the seasoned HR and IR professional. And to kindly subscribe to my YouTube channel Murali HR. Today we are going to see about the Section 10 of ID Act, how the appropriate government role will impact the cases with the citations. What is called as Section 10(1) of ID Act? The 10(1) of ID Act talks about the government can refer the dispute at any time it believes that industrial dispute exist are likely to occur. The government can refer the dispute to the board for settlement. The government can refer the dispute to the court of inquiry. The government can refer the dispute to the labor court for adjudication and if relates to the matter of second schedule. The government can refer the dispute to the tribunal for adjudication if it is related to the matter of third schedule. Now, the reference means what? The reference means normally the Board of Conciliation or conciliation proceedings will happen if the cases are filed by the individual workman or the trade union with respect to termination or strike or lockout, all these things. So the conciliation proceedings, failure proceedings will be forwarded to the respective state government, and the state government will review and if any apprehension on its own, if the dispute exit or the dispute is necessary for reference, need for reference, then it will refer the matter to the industrial tribunal or to the labor court, because the state governments, normally the governments are only the administrative body. They are not the judicial body. So they are not even the quasi judicial body. They are the administrative body. They will they will decide on administrative side whether all materials are available and the matter is ready for reference to the labor court for adjudicate, and the all the documents records are available for ready reference. All these things will be decided before the reference. Now, the reference made without hearing or other party under principles of natural justice and subsequently heard before the reference. Court criticized under the Abdul Salam versus Government of Tamil Nadu. In this case, the government automatically referred the matter to the labor court, and the court rejected the things because the other party is not heard under the principles of natural justice in Abdul Salam case. And the another case, Kirloskar Electric Company versus Workman, the reference was made without hearing the manager, but the court observed that there is no necessity to hear the management. So that is the another observation by the in the Karnataka High Court. And in the another reference, the industrial dispute exit or the apprehended is important to refer by the appropriate government. So, the dispute exit or apprehended, the government decides that that matter to be referred, then they can refer the dispute to the court for adjudicating the matter. The time limit is not the mandate before the respective government. So there is no time limit to refer the matter to the government. And also the court cannot ask the government why they have not referred the matter in time or something like that. The appropriate government can keep the matter for deciding the matter and on based upon the material, based upon the facts behind the dispute, all these things. Because in many of the cases, the reference was made because of political pressure. Example, if the party, ruling party is in the coalition, the partner in the political party may be the affiliated union from the respective company. Automatically, the conciliation authority decides the matter and forwarded the matter to the state government. because of political push. So automatically the government will forward to the court, or the government themselves refer the matter, or the if the if the company is not for the doing the favoritism or something like that, they can reject the claim made by the workmen or the union. Then the matter will be kept by the government in many of the situations. That matters and all decided by the court based upon the facts of the matter. So here there are two things. One is court decide on the matter involved in the dispute referred by the government. But the government decides merits of the things actually. So they are the authority to decide whether the matter can be referred to the court or not. Or return means if they are returning the matter to the parties, petitioner, then they have to give the facts why they are returning the matter. So that and all very much important. We will see in the forthcoming slides. The provision must be complied and obligatory. So the whatever set in the ID Act under section 10(1) and other matters to be observed properly by the appropriate government before referring the dispute to the court. That is referred in the DA Korenkanar versus State of Bombay. Now, how and when to refer by the appropriate government? If at all any dispute exists or the apprehended, then the matter can be referred to the court. Or the government, the appropriate government themselves can take up the matter into their custody, and they can try to resolve the dispute, or they can get the opinion from the labor court and they will give the award based upon the law prescribed under the respective act. They cannot go beyond the whatever set in the act. Then, what is the availability of the material? Based upon that only the appropriate government scope will be decided. Then, real and bona fide discretion is exit. See, here the bona fide means the appropriate government felt that the matter is very important and that has to be resolved, the dispute to be resolved immediately. Then the appropriate government will decide the matter. The judiciary having the power to reject the reference if any deficiency. Here, the appropriate government has to they have to be conscious when they are referring to the labor court authority. Otherwise, the judiciary will ask why the other party is not heard, or why the material has not been reviewed by the appropriate government while they are referring to the labor court and all. So they must be very careful when the matter is referring to the authorities. And there is no time limit to refer the matter by the appropriate government to the judicial authority in the case of Salibar Works Limited and its work. In the case of Sankari Cement ஆலை தொழிலாளர் முன்னேற்ற சங்கம் versus Government of Tamil Nadu in the year 1983, it's a very benchmark judgment. The government refuses for the references. Then the matter is heard by the apex court to make the reference. The Supreme Court overruled the earlier decision in case of reference of State of Madras versus Sarathi and Bombay Union versus Journalist versus State of Bombay. Here, the court, earlier the court said that the matter is not referred because of deficiency in the appropriate government review, or the other party has not been reviewed. In that case, that has been rejected. But in the Bombay Union Journalist versus State of Bombay, in that case, the matter is referred even though that has not been reviewed by the appropriate government. Now we are going to see what are all the cases the Supreme Court reference is on merit is okay. In the case of Nirmal Singh versus State of Punjab, Irrigation Karmachari Shangan versus State of Madhya Pradesh, Veera Ranjan versus Government. Now we are going to see some of the famous Supreme Court judgment. The Supreme Court asked the state and the parliament to make the amendment in the legislation to avoid the timings by going to conciliation and making reference on failure. In the case of Rajasthan State Transport Corporation versus KRI Shikant in the Supreme Court. Here, in this famous judgment, the Rajasthan State Transport Corporation, the Supreme Court observed that there are so many stages to resolving the dispute. The workmen or the union have to make so many steps to get resolved their dispute. So the Supreme Court asked the state governments and the central government to make the legislation and avoiding the in between the judicial authority, like conciliation authority, is not, they are not deciding the matter. They are only compromising, conciliating the matter. So now most of the cases are going to either to the appropriate government and referring to the labor court for adjudication. The time spent by the aggrieved party is taking more. So they observed in this case like that. In the case of Delhi administration versus workmen of Edward Conventas, the appropriate government referred the matter partially and the judiciary only adjudicates those matters and the rest is resolved by the writ. Here, the writ petition, the appropriate government referred the matter partially. They have not fully forwarded, but the matter is adjudicated by the labor court. So there is no problem when partial forwarding the matter to the labor court. Some of the matter can be resolved by the appropriate government themselves. In the case of Delhi administration versus workmen of Edward Conventas. In the case of Pradap Singh versus State of Punjab, court reviewed the matter for referring and not other things like canvassing like that. The matter court objective is to resolve the matter. They will see the material fact and they are not going to see any other party is like-minded party or political party or something like that. That is observed in the Pradap Singh versus State of Punjab. This is one of the famous case law, State of Madras versus C.P. Sarathi. Here, the court observed that the subjective opinion is important while they are referring the matter to the court, or otherwise, the matter will be dealt under the Article 226 by the High Court and they will decide the matter. In some of the cases, like if some of the matters, the matter will not be resolved immediately, then automatically by the way of writ, they will get the aggrieved party will get the dispute get resolved. That is dealt under the State of Madras versus CP. When the court entertained by writ, the court themselves will ask the appropriate government by directly the aggrieved party can approach the court and they will, by the way of writ and asking the appropriate government for the delay and all. So what are all the when the court will intervene in the under the section 10, non-application of mind by the appropriate government. The appropriate government has not consulted either party or they are not factually deciding the matter and they have not analyzed the material involved in the matter and they are not deciding based upon the what is in the law. Those times the writ will exit. Activity carried on its not industry under no ID. In the case of Pripachi Sugar Mills versus Pripachi Sugar Mill Mazdoor Union, Justice Venkatrama Iyer pronounced that, say for example, after closure of the industry, here the Piparia Sugar Mills Mazdoor Union raised the dispute and Venkatrama Iyer observed that when the factory is closed, industry is closed, industry does not exist, so there is no dispute prevails. Automatically, the ID cannot be sustained in the matter of Pipachi Sugar Mills versus Pipachi Sugar Mills Mastur Union case. And improper opinion of the government. Some of the times, because of as I already said, some of the favoritism or like-minded political parties or coalition government, that affiliated union take up the matter and the appropriate government will forward the things, or they kept mum. In those times, the writ will sustain and they will get relief from the court by the way of sustaining the writ. So these are all the things I want to tell, and please subscribe to my YouTube channel. Thank you. I will see you once again. Thank you very much.